And right out the gate, we've got technical difficulties. Yeah, nothing says courtroom chaos like a defense attorney starting on mute. But trust me, this awkward start is just the warm-up for what's about to unfold.
Just saying. I'll pass that. Court does call the case of the people versus Christopher Day.
Good afternoon, Your Honor. Michael Doby for the people.
Good afternoon, Your Honor. Prosecution on behalf of Mr. Day is present to my right.
Your name?
Christopher D.
Hey. All right. All right. Date and time set for a preliminary examination. Are the parties ready to proceed?
We are, Your Honor.
All right. And
Here's the kicker: bond violations change everything. The moment a defendant violates bond, Zoom court is no longer an option. Translation: the judge wants to look you in the eye. No hiding behind a laptop screen.
And I would just say that we had an in-chambers conference. There were some legal issues raised, and so the court may not finally rule on those today, but we'll take the testimony in the case. My understanding is that there's particularly an issue regarding the Sheriff's Department policies. I will take that testimony, and then this court can figure out if I ultimately determine that I cannot use it, then I won't. Additionally, if the court does determine that the policies won't be used as the basis for the misconduct, and I inform counsel of this, but can be used in order to, as some substantive evidence regarding the particulars of an element, particularly the corrupt nature of the actions, then the court may indeed take that testimony for that purpose. But so we can move this along, the court will hear the testimony and then make a decision later as to how it will be used.
Thank you, Your Honor.
All right.
With that, I would call Kurt Sciapacasse.
All right. Sir, please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony about you, the truth, the whole truth, and nothing but the truth. So help you God. Take your seat. State and spell your first and last name for the record.
Kurt Sciapacasse, K-U-R-T, last name S-C-H-I-A-P-P-A-C-A-S-S-E.
Thank you, sir. What do you do?
I'm Commander of the Washington County Sheriff's Office.
And how long have you been in that position?
In that position since 2021.
Okay. And before that, what was your experience in law enforcement?
Started off at the Sheriff's Office in 2001. Was a corrections officer, was a field training officer, was a sergeant, no war, ran transport and port security, as a lieutenant, went through the police and corrections academies, went to the MSA, special investigations, did some work at the AG's office.
Thank you. I'm going to ask some questions about incident in the jail, Washington County Jail, March 18th of 2024.
Wait, hold up, he's blaming Uber for not being in court? Imagine standing before a judge and saying, "Sorry, Your Honor, no ride." That's like telling your boss you missed work because your Wi-Fi was tired. Not a great look.
Okay. Now, before I get to that, I suppose, do you know the defendant in this case? Christopher D?
Yes.
And how?
No, stipulate the identification and that he's a law enforcement officer in the employ of Washington County Sheriff's Department.
All right. Very good.
Appreciate that.
So stipulated.
We'll move along. Thank you, Mr. Gucher. When did you become aware of the incident in question here?
There was an email notification that was made at the time. D was a sergeant and he was working midnights, and I remember waking up and checking my emails the next day, and I saw an email notifying that there was a use of force in jail. I reviewed it. Things stuck out to me.
Tell me about that.
What immediately stuck out was that the email indicated that Sergeant D sprayed.
Oof, that's the courtroom equivalent of either you come here or I'll send someone to get you. With flashing lights, judges don't bluff, and this is basically your last warning. Before handcuffs.
A subject in the back seat of a police vehicle, an empty police vehicle, while she was in restraints.
Okay. That stuck out to you. What did you do?
Notified one of the lieutenants to evaluate the situation when it came to work.
Okay. And so why did that stick out to you?
So ASR spray is used when somebody is a threat, and because she was in restraints in the back of a police vehicle, bars over the window, I had concerns as to whether or not that person was a threat at the time of the incident.
Could you tell what is ASR?
Aerosol subject restraint, commonly known as mace.
Okay. And is that something that is issued to officers in the jail?
It is, sir.
Okay. And are there trainings regarding that
Yes, sir.
that are required?
And just like that, we pivot. One case stalls and another takes center stage. Notice how seamlessly the judge transitions. Courtrooms run on schedules, not excuses. If you're not ready, the show goes on without you.
Yes, sir.
And are there policies regarding that?
Yes.
And are there, what is done, if anything, to make sure that the officers know about the policies?
Anytime there's a policy revision or anytime there's a policy that's newly published, it's sent out in a program called Power DMS. The employees are required to review the policy and electronically sign, and yearly aerosol subject restraint. There's a training course that's pushed through Power DMS where the students have to participate in the training, watch a video, and then take a test.
Okay.
Successfully pass the test.
Specific to ASR?
Yes, sir.
Okay. Approach with people's proposed 4, 5, 6, and 7, which I've shown to Mr. Goocher. Thank you. May I approach you?
You may.
Commander, I've handed you people's proposed 4, 5, 6, and 7. Can you identify what those documents are?
4 appears to be an excerpt from the subject control policy. 5 is a use of force concept paper on the use of force continuum. 6 is an excerpt from professional standards policy. And 7 is an appendix that shows the resistance and control between the suspect and staff member.
Okay. And are those all Washington County Sheriff's Office policies?
They are.
Okay. You're familiar with each of those?
Yes.
And is it true that you had a hand in writing some of the use of force policies?
In the use of force policy, not the concept paper nor the professional conduct policy.
Okay. Your Honor, subject to your earlier ruling, I would move for the admission of people's 4, 5, 6, and 7.
Any voir dire or objection?
Just for clarification, those policies were in place as of the date of this incident, correct?
Yes, sir.
No other objections other than the ones already noted by the court.
All right, very good.
Thank you.
4, 5, and 6. 4, 5, 6, and 7 are conditionally admitted.
Thank you. You mentioned that it's the incident that you were things stuck out to you because it was a use of ASR against someone who was handcuffed in the back of a police car. Is that right?
Yes, sir.
And generally, from the what is your understanding from the policies of the proper use of ASR within the jail?
ASR isn't classified anywhere in the force continuum. It can be used any time that the person that's applying force feels that lower forms of control will not be adequate.
Okay. Lower forms of control, what does that mean?
Bustling techniques, placing someone on the ground, escorting them.
Okay. Tell me about what you said, something about the individual not being a threat.
Yes.
Where does that fit in?
So ASR is used when there's a threat to staff or a threat to another person. And as the victim in the case was in restraints in the back of a police vehicle with bars on the window, it was difficult for me to see what.
This right here is the heart of the case. Pepper spray or ASRIs meant for active threats, but spraying a handcuffed suspect locked in a squad car?
That's
Like using a sledgehammer on a locked door excessive and legally explosive.
Whether or not there was a threat to anybody else.
Okay. You talked about levels of clients using lower force to gain compliance. What does this mean, compliance?
To bring about a peaceful end to the situation, to bring about the lawful conclusion to an event.
Okay. When someone is, no, let's strike that. I'm not going to propose any hypotheticals there. Did you see, Commander, any justification for the use of ASR in that situation?
Objection relevance. Whether or not this officer sees that it's relevant is not the legal standard. Actually, under Graham v. Connor, it's from.
As to the form of the question, I'll sustain the objection. I'll allow you to rephrase the question, but I think as it's phrased, I think it's.
Thank you. In a situation like this, Commander Sciapacasse, where someone is handcuffed and in the back of a vehicle, is that based on both your understanding of the policies and your own training and experience, a situation where ASR would be necessary?
Based on my training and experience, what I saw, no. Okay.
And why is that?
Because the person was not a threat at the time that ASR was used.
Okay. Talked about compliance. What was being asked of the arrestee at that point to comply with?
Answering questions as to whether or not she was suicidal.
Okay. What the 3 core questions that was referred to? What are the 3 core questions?
You have medical needs, you take medication, or anything thoughts of hurting yourself.
Okay. And what is the purpose of asking those questions?
Just gauging whether or not they're going to be suitable into the jail to have the full medical evaluation done.
Okay. And if
Also gauge whether or not we can place that person on the observation to.
And if someone does not answer those questions, what is done?
It's not unusual. We bring them into the facility, search them, possibly place them on precautions depending on the situation.
Okay.
Cross-examinations.
Commander, briefly, were you going to get the individual out of the car?
I'm sorry, sir.
Were you going to get this individual question out of the car?
No, sir, I wasn't there.
Okay, so you weren't there, but you determined that there was no threat to the officers that were, correct?
Based on the circumstances.
Okay, were her feet restrained?
No,
What direction were her feet facing while the sergeant was talking to her?
I'm not sure.
Okay, well, if the feet were facing the officer, could that be a threat?
No, because she was in the back of
Okay,
the vehicle.
is that where she was going to be housed?
No,
Okay, so what do the officers have to do to house her?
move her from the vehicle.
Okay, so if they open the door and the feet are facing the officer and they're unrestrained, is that a threat?
No, that's typically how we get people out of the vehicle.
So you're telling me that it's not a problem for officers to be kicked?
No, I said that's how we usually get people out of the vehicle.
Right, but that wasn't my question. Is that a threat to have the feet unrestrained at an officer?
Depends on the circumstance.
Okay, so did you see the demeanor of the individual that was coming into the jail?
I did.
She was kicking the back of the windows of the car?
When she was on the way there, yes.
She was screaming, yelling, insultive, combative?
Yes, sir.
Okay. The officers have to make a determination to get her out of that car, right? How they're going to do it?
Yes, sir.
Now, the 3 questions were just a precursor to getting her out of the car, correct?
Yes, sir.
The officers were actually there to extricate her from the car and put her in a cell.
Yes, sir.
Okay. Sergeant Day and one other person, what was the other sergeant that was present? Do you recall?
We was Sergeant Merrick.
They're the ones that are in charge of getting this individual out of the car,
Yes,
right?
sir.
The other sergeant was a female officer, is that correct?
No, sir.
No? Were there female officers present?
Yes, sir.
And that was in part because not only